Okay, so this last week saw three very major oral arguments in three different cases. We've got Mock v. Garland, which is one of the pistol brace suits. We've got Junior Sports Magazines, which involved the California's prohibition on advertising firearm and related products to minors or in some way that may be attracted to minors, which is why all of a sudden you saw many of your favorite websites have those "Are you over 18" banners pop up. And then also the Illinois assault weapon consolidated cases.
Yep.
So we just thought it would be a good idea. We've gone through all of these hearings. We listened to them all. We got our notes here. And just kind of give you guys our take on the matter, what might be coming through them. I do want to say, just as a preliminary thing, I don't want this to be taken as us criticizing the lawyers that are involved in these cases or, Monday morning quarterbacking. Because, look, we weren't there in the lead up to these motions and the lead up to these hearings. And there's a lot of factors that go into how the lawyers perform at oral arguments, not the smallest of which client expectations, and the clients can tell you what they want you to say, what not to say. So there may be some criticisms we make or things that we didn't like that were said that were beyond those lawyers' control. So just want to get that out there because I know how frustrating that can be. But to start with, let's talk about the Mock v. Garland, which that was up at the Fifth Circuit. Their expedited hearing on basically what was at the lower court a denial of their motion for preliminary injunction. And this is one that, of course, we've all been looking at pretty closely. The question is, what is the injunction going to look like going forward? Is there going to be injunction going forward? What would that look like? And also, just generally, how are the lawsuits shaking out in terms of the pistol braces and their legality? Right. Do you have any initial takes before I start going through my notes?
So this case was pretty interesting. So we knew going in, ATF was kind of on the back foot because the injunctions hadn't been nationwide, but then the injunctions had been for the specific groups, the plaintiffs in these cases. But then, in a clarifying order, in a rather unusual clarifying order, the judges in these cases granted relief to the members of the groups who were suing on behalf of their plaintiffs. Mm-hmm. Now, of course, the thing that the ATF stomped their feet about and threw a little fit over was, but we don't know who's in these groups, and these groups don't. And to some extent, this is true. These gun rights groups, didn't really have it's not like the NRA where it's got you're a member and here's your membership card and pay your dues every year. Yeah. Right. They don't, a lot of these groups didn't really have something so formal prior to this. So the ATF was mad because, effectively what this was a nationwide injunction. They just didn't say so. Right. It was, a de facto nationwide injunction from a standpoint of what can the ATF do to enforce the thing they want to enforce. Well, they can't. They'd be running a massive risk of, being in contempt of what this court's told them to do. Yeah, no, they, it's one of the things that was said here is that this is the lawyer for the state of Texas who had divided argument time said that it would be wildly inequitable and chaotic way for the ATF to enforce the brace rule to basically demand proof of membership from people. Right. And that there's no way ATF should be able to be enforcing this thing as to some people and not as to others. And I totally agree. And so I guess let's talk about that. It's the big issue first. So the question of what the injunction would look like. So the lawyer for the state of Texas, he was arguing that a nationwide injunction is proper, as it was in Feds for American Freedom. But, he argued in the alternative that if you don't want to do a nationwide injunction, because the court was kind of pushing back and saying, well, aren't there other circuits that are dealing with this? There's no fewer than two other ones that are dealing with this. Shouldn't we let them kind of hash all of this out? Well, then he said, well, at least the Fifth Circuit, and at the bare minimum, the state of Texas. And I think that's going to be an argument you're going to see parroted in other cases, that these should be nationwide because it is wildly inequitable. And it also creates it's kind of perverse
to have a
it creates a disparate system of justice from federal authority,
right,
relative to different places across the country, and it's ridiculous.
Yeah, and also they brought up the recent Harvard admissions case, where standing was found to be good in the case of an unpaid organization. So, there was back and forth insofar as that, but I mean, it's kind of a double-edged sword. You want to get this nationwide relief because these gun rights groups don't want to. It's an awkward position for them to disclose their member lists to the federal government, which would be the next step, right? If this continues the way it is, and I don't think the feds would be too averse to demanding that, really.
Right. Certainly the feds will demand it, and so it's just a question of if the courts will compel, like, that's the way that this relief be dished out. Because, if you today were given trouble by the ATF and they asked if you're a member of this group, you could just shrug, right?
Right.
You wouldn't have to answer it or prove it, because it would be on them at some rate to either prove you're not or run the risk of, it turns out you actually were, and now they've hassled you and they violated what this court told them they were supposed to do. Right.
And so the government's position was that the court didn't have the power to enjoin conduct beyond the parties themselves. That's not true.
Yeah, that's definitely not true.
It's completely not true. And so in the government's position, they said, well, please just get rid of the injunction. And if you don't get rid of the injunction, well, I guess just keep it as to the the plaintiffs. And then the government specifically asked the court to carve out FPC members from the injunction. And it argued that there were open questions as to whether that group had shown that it was a bona fide membership organization, and a real struggle as to whether the appeal court ought to retain jurisdiction with an injunction or hand this back to the circuit court. And that is it's a super awkward position.
Right.
Of course, the lawyers for the group replied. He completely attacked the assault on the organization's institutional standing based on the Harvard case, and argued so that's kind of the scope of the injunction question, right? And it was not, I'll tell you, it wasn't super clear how the court was going to go in that respect. There seemed to be some appetite for handing it back to the lower court to deal with. And of course, they could do this by saying, by basically directing the lower court to enjoin the conduct.
Right.
It is mechanically awkward. It has been done before, where the appeals court maintains this, basically the Fifth Circuit maintains this injunction as the case is continuing down below. It is a little bit procedurally awkward, and the government has put itself in this position by so aggressively pursuing, effectively, the ability to arbitrarily enforce this rule. So it's kind of a forced issue,
right?
If you ask me. So when they were getting down to the merits of the thing itself, one thing I always hate to hear is, and immediately plaintiff lawyers brought up the dangerous and unusual test, and the court was going back and forth with them. So yeah, right, it's a two-pronged test, right? Is it dangerous and unusual? And I hate that there's no resistance to the concept of dangerous and unusual as a test.
Yes, it's not.
It doesn't exist. And the more we're coalescing around that, the worse it's going to get.
It wasn't even articulated as a test ever. It wasn't even proposed.
No, it was. This all goes back to Heller citing that there are some historical laws, right? And this all
was giving an example of something that might be. It was giving an example, not even specific to the issue at the thing at issue in Heller. Just an example of, like, here's a historical law that's consistent with the tradition of regulation, and it was a regulation on the carriage of dangerous and unusual firearms in such a manner as it would inspire fear in people.
Yes.
Like
And so
waving
it
guns
goes from
around and
4 elements. And it wasn't just firearms, the dangerous and unusual arms, because this goes back to
Right.
pre-colonial, like pre-founding era.
Scared of
stuff.
people with their little dirks and daggers waving them in people's faces, highwaymen and such.
Yeah, and it was inspired by, like, you really have to understand the historical context of these laws, and that's why it's important that we maintain historical context and that we be forceful about words and how we use them. So, and that's something that not many people agree with me on, and I'll openly admit that. Some people say it's perfectly fine to jump the gun and skip to a question of whether it is just dangerous and unusual, because I think it's problematic because it kind of seeds an argument that no one needed to seed.
Yep.
So the counter argument would be, if it's okay to prohibit the carry of dangerous and unusual arms, well, if you're talking about the regulation of just a dangerous and unusual arm, if it's not both dangerous and unusual, then it shouldn't be okay. But I think that, it skips 4 steps.
Right.
And it allows the government to just kind of sit there and assert repeatedly that something is dangerous and unusual. And right now, it seems the prevailing belief among firearms practitioner is, and by the way, if you never argue that it's not, it winds up being the rule. But
right.
For now, the prevailing assumption, it seems, is that if a firearm is both dangerous and unusual, then it is immediately regulable. And
Which
I don't think
true.
there's historical context.
That's never been articulated as a test. And really, if you're looking for historical context, at best you're digging through analogies like, oh, well, some state said you couldn't have a Bowie knife. Is as close as you get to some sort of example of dangerous and unusual.
Although it has, to be fair, it hasn't been articulated as a test at the Supreme Court.
Right.
There's been several courts of appeal that have been very excited
that like to invent these things.
Yeah, to accept these concessions. But anyway, so that was just one little thing. So there was good arguments from the plaintiffs about historical analogs. ATF has been hanging their hat on colonial era and colonial and pre-founding and immediate founding era door-to-door inspections of people's firearms. And ATF is saying that, oh, well, registration is akin to that.
It's again, like, Bruin tells us we look at the how and the why.
Right.
The why, I agree, it's actually probably pretty close. The how is complete. I mean, it's utterly different.
Is it close for the why?
They could articulate a way that it's close for the why. Probably, if you look historically, no. Well, historically, it's because they wanted you to be able to be ready to fight a war at a moment's notice,
and they wanted to make sure that it's because they wanted to make sure that your musket was the right caliber and that you had it. Right. So that you could use community ammunition reserves and, like you said, fight it at a moment's notice. That they were not checking to see that you had, whether your musket or whatever the case may be, was too out there. In fact, they would have been, if you had a very cool musket, they'd have probably been like, neat. Is that 69 caliber, which most of these required, right? None of those early regulations ever resulted in the confiscation or criminal treatment of a particular arm if it failed examination. The result would be another gun.
And they certainly wouldn't amount to fingerprinting and background check and everything that regulation implies. And you can't cross state lines without letting them know in advance and all this insane stuff.
Right.
So in that regard, it's definitely not how, like, it can't, not even close to how, like, maybe they could they could convince a judge that wanted to be convinced on why, but there's no way on how.
It's just not. So the key point is you don't have to find a historical twin, right? So there's, because you're not going to, barrel length was just not a thing for ever.
Right.
Handguns were a thing, but good luck, what with Heller now. And those were only enforced against people who
the government wasn't fond of.
Yeah, they weren't fond of. Another thing, so as they drove through that dangerous and unusual thing, they asked lawyers for plaintiffs, well, what about sawn-off shotguns? Is it okay to regulate sawn-off shotguns? Because they're wanting to tie it back to Miller.
Right.
And the way they grappled with this is by saying, well, I think a sawn-off shotgun is different, right? Because a sawn-off shotgun is wildly inaccurate and has a lot more risk of collateral damage.
Okay, I'll out myself as a turbo FUD here. Shotgun barrel length has almost nothing to do with the extent of spread, provided you're using a choke. It's really there for sight radius and for swing on shotguns you're going to be doing moving targets with. It's the only reason that extra barrels help you is for sight radius, for swing, having more mass further out. From a standpoint of how tight the thing groups, right? It's not like a rifle. There's no stabilization of projectiles in there. There's really no convergence of projectiles except for whenever you get to your choke. So provided you've got a barrel that's like at least 6 inches, you're going to have your shot pattern disperse to the point it's going to disperse in the barrel. And once it hits the choke, it's going to converge. So that's
of course, most like the point of sawn-off shotguns is that they would be cylinder bore.
Right.
And then really the spread on a cylinder bore shotgun, more a question of wad, isn't it?
Right. Yes. So wadness effect on flight control will certainly make a difference. But the question of sawn-off shotguns, really shotguns in self-defense in the first place, is like a 15-yard question.
Right.
And the spread, even on a cylinder bore, something that's got itty bitty little barrels, it's
measured in inches.
Right. Maybe with buckshot, you might be like 2-3 feet, maybe.
At 15, but not...
If it's got poor flight control, like you're using something with a paper wad or whatever, maybe you could get 3 foot of spread. But that's not a question.
15 yards, you reckon?
Maybe.
Okay. Yeah, I guess I get what you're saying is if you like very haphazardly like hand loaded a shell with oblong sized projectiles,
like worst case scenario,
chewing tobacco.
Furthest extent of spread case scenario. It's not like you're going to be knocking out the whole neighborhood with your one little shotgun shot. It's not. It's not going to happen. And this is this ties back into something we've talked on before, where usually these issues are avoided by you having the lawyers be gun people, right? Because if they're gun people, they're usually a little bit more hesitant to say stuff that's like, I don't think that's right.
Right.
Or all the way up to like sometimes they say stuff that's just patently untrue. But then the other gamut that you run there is sometimes when you have pro gun lawyers who are gun people, they end up like having this incurable case of like FUD / boomer brain.
Yeah.
Whereas
and then the other risk of winding up gunsplaining to the judge, which you don't want to do. And this is I've been, because of some of the cases I'm involved in, I've been talking with some other practitioners, and the thing that we kind of rested on here was, as we were talking about some of these arguments, is that there is just there's a substantial dearth of attorneys in the field who are actually gun people,
right?
Like who you can prove have shot a gun, as I've repeatedly said there. And then two, for those that are in the field, that are out there, there's even fewer of them that are actually willing to practice.
Right.
And bad facts like this can wind up making bad law. When you represent situations that are not true. Now, of course, all that to say, was the sawn-off shotgun question like determinative?
No. But this is sort of a thing that can make a pattern of, and much like in a lot of these gun control laws, right? If we take a step back and look at the political, like the legislative end of this process, I guess the beginning of it, really, a lot of the times the things that get banned are just banned because of one idiot FUD anecdote, right?
Right.
Like things will be thrown into these bans because in the case of, we're going to talk about Illinois' assault weapons ban, they decided to not exempt 22s because
stay tuned for that, audience. We've got some whining to do.
One miniature brain politician from Illinois was like, oh, but what about the Tech 22? It's a notorious gangster weapon. We have to ban that. Like, is there really? There's a lot of drive-bys with Tech 22s these days, and because of that, all rimfire guns are subject to the assault weapons ban as a result of that insane. And the Tech 22, Tech 22 that's been out of production forever, and even when they were in production, they didn't work.
I have one. It's
they're terrible.
It's locked up. It's locked up in a way that I can't even. And I'm good with. Ivan can speak for me. I'm pretty good with guns mechanically, right?
Right.
I cannot figure out a way to take this thing apart and it's locked itself together.
And so, much the same way, like just silly anecdotes end up making bad law. In the courtroom, the same sort of thing can happen where
because it's going to get repeated is the thing,
right? It can be a lawyer doing it. It can be a judge doing it, where they just throw out just the most bizarre anecdote. And if it doesn't get knocked down and people decide that this is actually true because, well, he's wearing a funny robe and a powdered wig, surely he knows what he's talking about.
Right.
It can end up
and we'll get to that about the Illinois assault weapon question.
Oh yeah, it really took off there.
Yeah, it was zooming. But so yeah, that's. I just think there was a better way to answer that. But again, I'm not here to quarterback it. I don't think that materially affected the case.
No.
Again, we're just kind of complaining that there's not. And I know I always encourage people not to go to law school, but I'm actually at this point starting to think, if you're willing to donate your
life and your sanity and
all of your usefulness, and you are like firearms literate, maybe consider it, because we definitely need your help. So moving on now, when they start to talk about the NFA, because here's the other question, and this is something that is diverging in this field, in the pistol brace lawsuits, the questions of what kind of relief they're asking for. Are you asking us to, like, basically, at me speaking as the Court of Appeals, are you asking us to strike down short-barreled rifle regulation under the NFA, or are you asking us to strike down this rule and return to the status quo ante?
Right.
And there was a little bit of spaghetti coming out of the pockets of the attorneys when this happened. So the institution lawyer straight up says, I'm not asking you to strike the NFA provision. I'm asking you to strike the rule. Well, they did ask, in the original lawsuit, and then he kind of backpedaled and said, oh, well, I mean, we are, and I'm not going to tell you not to do that. But right now, he said he's asking them to restore the status quo ante, specifically ask the court to restore ATF's prior determinations and basically put the state of administrative rule exactly the day before the introduction of the final rule. And I don't know if that's something the court can do.
It's an interesting legal question, right? Because from a standpoint of the sort of relief a preliminary injunction's meant to give you, I think that's close. You enjoin the ATF from enforcing the final rule, which is effectively you put things back to the way they were. But from a standpoint of,
but do you? That's the question that the court was kind of pressing here is, okay, well, if we just get rid of the rule, aren't they just going to be able to, because the court was saying, ATF is saying that this is the way the law always was. So what's going to stop them from, and this kind of gets to the bad end situation that we were talking about. If we just get rid of the final rule, what's going to stop them from just privately making these same exact determinations?
Right. So they have to be enjoined from their rule-making authority, or their ability to go and paint anywhere outside the lines at all.
Yeah. So
they can't. It like has to say stock on it to be a stock, basically. Right. Something to that extent, or perhaps I think I would have liked to have seen plaintiff lawyers try and paint like the three scenarios that you can sort of see here, where the ATF's just enjoined from enforcing this rule, the rule goes bye-bye, or it's the NFA. And I would have liked to have seen just get rid of the NFA being that this is the easy solution that makes the most sense under a law.
Well, it does make the most sense, because there is no, and they kind of got to that. But they didn't grapple with the question of barrel length. They said, one of the judges was saying, well, doesn't this make a gun safer? He asked of the government's lawyer. And of course they wouldn't answer. He said, well, it depends. It depends. And the government's lawyer admitted that there are some instances that a brace makes a firearm safer to use. But then he also said, but it also makes them more deadly. And I think the thing that none of these lawyers have engaged with is just, guess what?
Good.
Guns are dangerous.
Right. The more
the question is, do we want you to be able to put the energy where you've directed it? Right. And the same, being able to direct that energy makes the gun more useful for lawful use. It also makes it more useful for unlawful use, but that's not That's not the question, right? That's
Right.
that's a question of right. And so, and again, going back to the NFA question, the Texas lawyer, they kind of slapped him because they straight up said, they were like, well, does not Texas law directly reference the NFA? You regulate possession of a short barrel rifle.
Yeah.
And Texas was kind of like, and the court said, if you win, it reverts back to what? They just decide case by case as they always have.
At the end of the day, right? Unless the ATF is enjoined from their ability to make these sorts of determinations on their own, like in an ideal world, right? In an ideal world, NFA goes away. But if we can't have that, the relief that gets passed down is something like the NFA has to say, publish on a case-by-case basis whenever something isn't okay. So they have to say, like, this individual gun set up this individual way isn't all right.
Right.
And they wouldn't have the ability to pass some, across the board rule where it's like, actually any configuration like this isn't okay.
Which, let's be real, that's what they were trying to do. And the government's lawyer was trying so hard to say, trying so desperately to say, well, it doesn't categorically ban braces.
Right.
And said, and like cited things that were nowhere in the final rule. Right. Saying, oh, well, but if it has some kind of protrusion that makes it uncomfortable, it's like, well, where was that? Where was that?
In this, it really just speaks to the, and perhaps they should have been called out for this by the judges harder, but it speaks to the true arbitrary, like the level of arbitration in this rule where the ATF can just stand in front of the judges and be like, actually, the rule says this, and it lets you do that, and also it's this, where it's like it's the flip of a coin that means something different. Well,
and the ATF's actual response to that concern was saying that, oh, well, any gun owner is free to apply for the tax, apply to register their firearm, and then sue for a tax refund if they disagree. Like, holy shit.
That's not a solution.
It's like you just said that. But yeah, I did think it was one issue I had was they're standing on these old ATF letters, like with certainty, saying they want to be back at the point where those old letters were. That's problematic.
Yeah,
to me.
I don't think that fundamentally helps us out.
And so when the Texas attorney said that, the court said, the court says previously, they published the rule with the point system, and of course that was jettisoned. But before that, it was kind of a black box when ATF would decide, is this an SBR or something else? And he said, is Texas's goal here to get back to that black box? I don't understand. And like I said, this is why I'm saying this isn't a criticism of the lawyers or the arguments that they were making. This is me saying I don't understand the extreme reticence to say simply, this is a regulation on handguns, right? And if the law, right, if the ATF is saying that the law properly understood includes all of these multiple millions of firearms that are lawfully owned, well, then that law must be unconstitutional.
Right. We have a irreconcilable conflict with what Heller laid out and Bruin affirmed.
Mm-hmm. For sure. Yeah, and the another interesting issue there was that Texas came up really hard with the tax argument, which I loved. He said, ATF has stated as a categorical matter that they have unchecked jurisdiction to approve or deny any application to make an NFA firearm. So that's not a shall issue regime, right? There's no plausible way to say that's an exercise in taxing authority, and no plausible way to say that applying it retroactively and waiving the tax and subjecting them to punishment is a constitutional exercise of the tax power.
Right. There's no revenue generating purpose in something that you can say, actually, you're denied.
Right.
You're denied giving us money.
Right. And especially where they are checking whether you are complying with local law.
Right.
Which is 180 degrees away from
Oh, right. I
prior.
mean, that's like extremely irreconcilable, right?
Right.
Because like the IRS doesn't check that like them demanding money from you is okay with local law, because your local laws couldn't pass a law that says like, oh, you don't actually have to pay your federal taxes. Oopsie.
Well, and that's why, like, this is all built on a like very delicate legal framework on why this is why you can declare your income from illegal activities,
Right.
and they can tax you on it, and you're not supposed to be subject to any consequences for doing so. So how come they get to do it here?
Right.
It's very powerful, and the government has made some, I think, very weak arguments against the taxing power concern. But I think that this is a very strong argument, and I regret that I don't really think that that's the way the case is going to be decided. Because if it is a taxing power analysis, guess what? The result is the statute being unconstitutional, or at
Right.
least this mechanism of enforcing it being unconstitutional. And I think that's a correct outcome.
Yes.
I certainly think that's a correct outcome. But yeah, they had a pretty strong finish. So the plaintiffs, the government was doing a lot of squirming. They were saying that the funny thing is the government keeps saying, oh, well, the APA claim shouldn't go forward because we didn't actually have to do notice and comment, because it's just it's an interpretive rule.
Which is very funny. It's like, oh, you can't sue us because we said it was always this way. Like, that's a stupid argument. Why would you say that?
And so for those of you guys at home, we're all at home. I'm at home. The question is why this is relevant, whether it's an interpretive rule or something more substantial, is that interpretive rules, you don't have to go through notice and comment, and you do not trigger a lot of the responsibilities that the government would have under the APA. So they're arguing that this is not a substantive rule. It's a simple mere interpretation of the statute. It's a simple multi-hundred-page interpretation. So the government invites them to see this. The government says, would you agree that this is a substantive rule, or are you really going to stand on it being interpretive? And the court said the rule itself said this is going to cost millions, and that 3 million Americans are going to be substantially affected. That sounds immensely legally consequential. And the government's like, well, in FAA cases, we've made really substantial interpretive rulemaking. So, and then the court said, can you think of another interpretive rule that the government put through notice and comment when it didn't have to? And you know what the government said?
They can't.
Oh, no, they said the bump stock rule.
Oh man! Oh,
and they were like,
dumb. That was so dumb. Why would they say that? In the Fifth Circuit.
In the Fifth Circuit.
They've been like, none come to mind.
Yeah, they said that is really problematic for you to rely on, considering Cargill, where they slapped that rule.
Right. Also considering, I don't know that anybody agrees that bump stocks were an interpretive rule either. And it only added like a sentence. It only added a sentence to the way it was, and I don't think that was an interpretive sentence. I think that was a redefinition.
Right. So again, then the court said the final rule seems to subject the ATF with complete unchecked discretion to assess the weapon with half a dozen opaque factors that people cannot see, which is true. That's what the final rule does.
Yep.
And you know what the government said to that? Your Honor, that's how intent determinations work. In criminal prosecutions all over the country, there aren't points-based worksheets to determine whether or not you intended to violate the crime. Well, it's correct. In those criminal prosecutions, but not in a massive administrative rulemaking that seeks to predetermine the criminality of intent-based conduct.
Right.
So I think the government is losing here.
I think so. And the funny thing is, I think it's more the government's fault than anything. Because I mean,
absolutely the government's fault.
I think plaintiffs' lawyers did an okay job, but I think they could have done a much better job just by being aggressive, right? And they were probably there was a tactical decision to play it safe because they might not have known how this panel was going to go, but I have to imagine there's at least some desire there where they're like, we really should have hammered the NFA points home because the government was like kind of tripping over themselves as far as not. I mean, just mentioning bump stocks was a really bad move for them. Where the court asked them, "Has there been any other time that this has happened?" They're like, "Oh yeah, the time we lost, the time that you guys you guys specifically just looked at, yeah, and then you said we were wrong. Remember that time? Yeah, that was the other time." Like, why would you point that out?
Yeah, it's again spaghetti. They're like, "Oh, I just gotta put this ravioli back in here." But yeah, it was brutal. So I think that the government is losing. The issue is that there's no one who can tell you what losing looks like right now.
And what's the scope of relief gonna be? I mean, just given my gut feeling after hearing the panel, I don't think that they're going to rule against the NFA. I'm also not.
Well, they're not on that point right now.
Right. But they're not going to enjoin the ATF from doing an NFA.
Right. Exactly.
Or even the SBR provisions of the NFA. I don't think they're going to go that far. I think probably the decision point will be between, do they keep the injunction that's already in place? Do they expand it to nationwide? Seems kind of unlikely. Or do they say the injunction can no longer be around? I think that's pretty darn unlikely.
What my concern is here is that in this case, and bear in mind there's many other cases, but that in this case, the court is kind of being spoon-fed to resolve the case on the APA grounds.
Right.
And the result of which would be going back to the way it was. That said,
right. The rule goes away and then the ATF can continue to be awful so long as Biden's president.
Right. But there would be case law saying that they couldn't be awful in this exact way.
Right.
So it would be better than the outcome would be better than, say, had the Congressional Review Act thing gone through. So it would still be better than that. It'd
be a tactical victory, but it wouldn't be like a resounding hurrah
long-term strategic victory.
Right.
Yeah.
Like, down the road, it'll help that it's the surprise tool that helps us later. Hey, ATF, you can't make decisions like this on your own out of nowhere and add hundreds of pages of interpretation to the definition of something that's like a sentence.
Right. And there was actually one point where the judge said, well, if we do this, then it's just kind of the statute sitting out in a vacuum. And I think you could kind of hear the judge thinking as he said that. And I think he was like, and because what I thought is, yeah, and right, like the rule of lenity is important, and so when you do have the statutes, and like it's not quite a vacuum; it's against the backdrop that it must be construed against the government, which is what we need to get back to. So anyway, final points on our reactions to that case. I think, well, one, I think everyone did a good job except for the government. Right, so let's just say that I think everyone did a good job. It is hard work, and it's very hard to be on your feet like that. And they did. There was some artful lawyering all around. I think the Counsel for Texas did a great job with hammering home the tax issue, and the government didn't really rebut it that well. I think the Institutional Counsel did a pretty good job hammering away how the government does not have a historical leg to stand on here. So, but what that's going to ultimately look like, we can't tell you. And anyone who says they can is a liar, right? Unless it's the fudge himself, in which case he's breaking the rules. All right. So now why don't you lead us into the assault weapon case in the 7th Circus?
Oh boy. So if you guys are regular tuners inners of the channel, we've been following the updates, but a quick version is like January of this year, Illinois banned all of the salty weapons and all the magazines, and it was really poorly crafted legislation that they rewrote huge sections of over the course of like 5 or 6 revisions. Then they crammed this bill into a shell bill that was an act concerning the safety of amusement park rides and passed it super late at night. It was typical shenanigans going on. Now, through the bill's various versions, at one point it would have banned any gun that you can grip with your firing hand. Like if the firing hand grips the stock and the trigger, it's an assault weapon at one point in time. They did at least fix that language, but they left some language in where like a fixed magazine attached to a Remington 870, a pump action shotgun, right? If you have a fixed magazine that holds more than 5 rounds attached to an 870, that 870 itself is a high capacity magazine and can't be transferred, can't be possessed without registration. Like the 870 itself is a high capacity magazine because it could take with a threaded extension, you could put on a +1 magazine extension on a normal one. And it defines any magazine which could be readily restored, meaning without any actual manufacturing going on, just like swap out a part to be larger capacity. So it was a very, very cockamamie law. Mm-hmm. There was several lawsuits in the Northern District of Illinois and several lawsuits in the Southern District of Illinois. Without going too far into the exact details of that, the ones in the North fared poorly because they were also fighting locality bans, like the Cook County, Naperville, and Highland Park had their own like local level assault weapons bans that got rolled into the state assault weapons ban. The cases in the South went good. They got a preliminary injunction, which was stayed by none other than our good friend Judge Easterbrook. Easterbrook is known for such hits as McDonald. He was the one who got overturned by the Supreme Court in McDonald. He believed
a Reagan appointee.
Right, a Reagan appointee who believed to some extent that the 14th Amendment didn't enjoin the Second against the states. Kind of a crazy thing to believe, honestly, because what if the states didn't want to obey the 13th? Does the 14th not bind the states against the 13th? I thought we had a war about this. A little one. little known war.
Right.
But he was also known for the Friedman decision in Illinois, where he after Heller, right? Heller answered the question of, is it only muskets protected by the Second Amendment? Heller answered that in no uncertain terms. Right. And then expanded in Caetano and later. Right. But before Caetano, Easterbrook had decided that actually what's protected is muskets only. It's only the arms that existed at the time of the Second Amendment. It's the only arms that you can say are protected by it. So he was a little bit of a goofball in that regard. Yeah, he was up to some funny shenanigans, and he was also on this panel. Yep. So he was the one who stayed the injunction, and so we hated him for that. And then we weren't sure if he was going to be on this panel. Now, the Seventh Circuit actually has some pretty decent pro-gun fudges on it. Mm-hmm. But it's also got some really bad ones. And the two worst ones are this Easterbrook fellow, as well as a lady by the name of Diane Wood, who was a Clinton appointee. Mm-hmm. So you can imagine how far my heart sank to the floor when I opened up my phone there on the morning of the thing, because the Seventh Circuit is very dramatic, and they don't tell you who's on the panel till the day of arguments. So they keep you in suspense. And so I open up my phone, and I see Easterbrook, and I'm like, yeah, that's a given. He's always on these Second Amendment cases because he sucks. Mm-hmm. And then I see Diane. And there's also a Diane Sykes who's awesome. Who's awesome, right? And is just a good person in general. Right. I've only heard great things about her, and her opinions on gun stuff are great. And I'm like, oh, it's Diane. And then I read it's Wood, and I'm like, oh, fuck. This isn't good. And then the third judge was, I believe his last name's Brennan, and he's a Trump appointee. And he only got in like one or two questions during the whole thing, because I think he realizes his job there at this point is to write the dissent. Mm-hmm. And so Easterbrook and Wood both, from what I'm told, part of their spite for the Supreme Court decisions in Heller and Bruen is because they at one point were candidates to be on the Supreme Court, right, and then just never got tapped, never got the nomination, and they're salty about it. And so they want to do their own. They want to do their own nationwide precedents and stuff, and so they're upset that they can't. And so they're looking for some way to undermine Heller and Bruen. Which is so fascinating. At the center of this assault weapons ban case is the state's defense is that actually Heller proposed this. If an arm is in common use, then it is sort of not burdened by, you can't be burdened by laws restricting it because the people have chosen it. It said that that's why handguns are protected. The state of Illinois has decided that what that actually means is that if an arm is in common use for self-defense, self-defense being the only reason that an arm can be protected if it's commonly used for self-defense. And they further state that in order for an arm to be commonly used for self-defense, you actually have to be shooting people with it. And then further, the localities, I don't know that the state of Illinois ever adopted this, but the localities, Chicago, Highland Park, and whatever the other awful place is.
Right.
They have entered in their briefs that it is actually impossible to use an AR-15 in self-defense because it's excessive force anytime you use it, which is insane.
No, that's fine.
I don't know how.
So there are really two thrusts here, and that's one of them, right? This kind of absurd assertion that it's not in common lawful use for self-defense, but the other one that they're really resting their head on, and which led to the spilling of much pocket spaghetti, is the government's position here is that AR-15s and the like are regulable because they are materially indistinguishable from M16s,
yes,
machine guns,
and thus they're not arms under the Second Amendment, which is something.
It's not how this works, right? Specifically, Bruin said that 2 steps is 1 step too many. If it's an arm that's regulated, which anything you can hold in your right hands and cast wrath at another, then you need to engage in a Second Amendment analysis, right? Which is you need to find an analogous regulation. And so this, frankly, when I saw them do that, I was like, whoa, right? Because that's the type of argument that, frankly, I would make in the future in a machine gun case. Because also, I think it's right. I think it's right. I don't think that there's a material distinction, right?
From a legal sort of perspective, right? There's a lot of legal fiction that would tell you they're different. Right. From a material, like you put it in somebody's hands perspective, I don't know that there's that really. I don't think there's that much of a difference.
I can think of some arguments, right? And I was actually involved in, I won't say which one, but I helped in one of the amicus briefs in this very case, and I did a little bit of fighting with the other lawyers. But, the argument that I came up with, right, for there being a difference is that the selective fire weapons were designed for suppressive use.
Right.
Whether they're actually more useful for that is not right. You would argue is not relevant. Is that selective fire weapons are designed for uniquely. It's hard for me to even make this argument because I don't believe it.
Right.
But that is how I would have responded to the government's position, because the government's saying, well, there's no material distinction. It's like, okay, well, the material distinction is that this is designed for this type of suppressive fire, I
think what you're saying is it's designed for a type of fire that's not useful for self-defense, and by and large, in a sporting purpose, it's also not super useful.
Let's bear in mind that's also not the test,
right? And that certainly is there any lawful purpose is right. Right. And there certainly are lawful uses of suppressing fire or machine gun fire or whatever.
Well, and here's the other thing. The government posits that because M16s can be banned, so AR-15s can also be banned because they're like this close to one another. Well, here's the thing, government, they're not banned.
Right.
They're not.
There's many millions of them.
Well, hundreds of thousands in
of AR-15s, millions, but hundreds of thousands of machine guns,
of pre-86, transferable machine guns that anyone can own, provided that they have the pornographic level of expense, right? They're far too expensive because of the scarcity. But if you go to the congressional record, the government said in 34, you cannot ban these. Cannot. And they still have not banned them. They have made them disgustingly expensive, right? Which is all arms control winds up doing in the end. But so anyway, those are the two main points that the government's made is one, it has to be in common lawful use for self-defense, which is, again, this is the
shooting
opposite.
People.
Yeah, for
you have to be shooting people.
They have to be actively firing at other people,
right? Because they said storing it in your house. They said practicing with it, training with it, keeping it ready, even pointing it at somebody, right? Brandishing it against an intruder. That's not common use for self. Somebody has to be bleeding.
Got to be shooting it. Which is whoa. So this is the opposite problem, right? So I was complaining earlier that, hey, there's actually kind of this 4-part thing that the government has to prove, and you've seeded them down to 2. And here the government is saying, well, no, it's not just common use for lawful purposes. It's also common use in self-defense while actually firing at another. So like they've gone from, whereas we've kind of like allowed them to go from 4 to 2, the government's now going from 2 to 4, right? And it's equally problematic both ways. And this caused one of the organizational lawyers to just have a bad time. Why don't you tell us about that?
Well, so it was really interesting. So the line of questioning, it was Easterbrook, who was in his typical fashion. He's very smarmy. Anytime
he's also a bit, and I'm as a officer of the court, I'm not going to say anything about his abilities as a judge, but he does kind of have a reputation of being a little bit mean.
Yeah, he's smarmy, he's condescending, and anytime somebody pushes back on something he says, like he made things up during these proceedings, right?
Which he repeatedly insisted that machine guns were banned in 1938.
Yeah, he said that machine guns were banned in 1938 by the Pentagon because the Pentagon wouldn't sell machine guns to civilians anymore. That's plain old not how that worked, but like he kept repeatedly insisting this. And when one of the lawyers tried to correct him on it, he just started chuckling. Right. Like, oh, I know more than you. Like, oh God, just such a
very sportsmanlike,
vitriolic personality. But one of the lawyers he gets into a line of questioning with, and so they're dealing with this question of arms under the Second Amendment and what's bearable arms, because the state is trying to say that in order for something to be an arm, you have to be using it commonly for self-defense, which means shooting people.
Right.
And so
which is like, whoa, that is a fast train you took to weird town.
The one thing I'll say, I guess, in Easterbrook's, I guess there's 2 things I'll say in his defense total from these proceedings, but the one thing I'll say in his defense is he didn't buy that. He bought bearable arms, meaning bearable arms. It doesn't mean that you're shooting people in self-defense every day with them. But he asked.
I guess the proximity to Chicago has these people very.
He asked one of the plaintiff lawyers, "Does a grenade constitute a bearable arm?" And the plaintiff lawyer immediately jumps to spaghetti falling out of their pockets, like, maybe I believe that there's a argument that grenades probably aren't bearable arms, aren't protected by the Second Amendment because they're dangerous. And then Easterbrook's like, "Oh no, this is really simple. Grenades are bearable arms. You can hold them in one hand, right? You look, you could hold a grenade in your hand. It's a bearable arm." And that and Easterbrook tried to make that an example of, well, just being bearable arms shouldn't be the test. That
right.
the threshold for Second Amendment protection should be more than bearable arms. And so he starts talking about Stinger missiles.
Yeah.
Oh my God. He probably said Stinger missiles at least 15 times in the next 20 minutes. It was bad. He just wouldn't stop saying Stinger missiles. Would Stinger missiles be protected by the Second Amendment? Is it Stinger missiles? Stinger missiles are banned. Do you know Stinger missiles are banned? Hand grenades are banned, but they're bearable arms. See, bearable arms are banned all the time. That can't be the threshold test for if it's protected. Like he was intentionally missing the point that Bruin set forward, which is if it's a bearable arm, then presumptively it's protected, but historical traditions of regulations could then make it subject to regulation. That's what Bruin said, but he right. either doesn't get it or doesn't want to get it, which is,
and it wasn't fired back at him is my complaint. And again, I'm going to reiterate, I wasn't there. I don't have the clients. I don't know what the limitations that were put on these lawyers, but if it were my case, is just what and I know I'm totally engaging in the Monday morning quarterbacking right now, and I'm sorry, but I'm doing it with those caveats, just because I kind of feel like this is what our audience wants to hear is what's our opinions on the matter. In my opinion, and I think you kind of echoed this, if I was faced with that question, the simplest way around it is saying that's not in front of us today. That's
right. We're not talking about grenades, dude. Like I'd love to bring a grenade case right in front of you right after this, but that's not what we're talking about today.
Right, because I have theories for that too.
Common use frags, dude.
I think it goes down to a public nuisance question, and but anyway,
as long as everyone's having fun, you should be able to have frags.
Right. Probably. And depending on what the locality looks like, whether or not there's an actual nuisance argument to be made for. But anyway, get all that aside, the machine gun question caused about like a 20-minute aside. And so I will say Aaron Murphy is one of the most celebrated litigators in the US, really thinks well on her feet, like really performs very, very well, but is a very, litigates in a very wide range of issues. And just in this is what happens when you have very gun technical questions and somebody who is not very experienced with firearms, is they get caught up in these weird minutiae.
Right. So yeah, Easterbrook went down another line of questioning later where he was asking, aren't machine guns better for self-defense than semi-automatic rifles? And the way that he sort of presented this argument is, say you have somebody who has very little experience with a gun, maybe doesn't know how to aim it, and they've got arthritic fingers, so pulling the trigger multiple times might be hard for them. He asks, and I mean, this is I've listened to a lot of these proceedings, right? Just because I find it kind of interesting. I have never once heard a judge suggest that mag dumping a machine gun in your house would be more effective for defending yourself than like aiming a gun that's maybe capable of being aimed. And so, he was positing to Aaron Murphy that wouldn't machine guns be better for self-defense because somebody with little training and arthritic fingers could just hold down the trigger, hose down their whole house with rounds. And that somehow somebody who's not familiar, doesn't know how to aim a gun, right? You're so gun inexperienced, you don't know how to aim it, is somehow going to be capable of controlling a machine gun first off, and to avoid from just putting all the rounds in their ceiling. And in addition to controlling it, actually stopping a threat with it.
Right.
The obvious answer there is
the thing that Easterbrook was engaging there is he was trying to lead to a parade of horribles argument, right? Which is, oh, if I agree with you, then all of these horrible things happen. And so that's what was being teed up, and you go on with how that was addressed.
Right. So again, like, the answer there, at least I think, should be, we're not talking about machine guns, dude, as well as maybe with a little bit of like, give him a jab or something where it's like, we're not talking about machine guns. Hey, and stupid. That's not how machine guns work. It's not like the movies. You don't paint with them like they're a paintbrush. There are some machine guns that's maybe possible with, but like, by and large, machine guns aren't something that you would do a good self-defense with in such a scenario. Right. Especially if you're like undertrained and not capable of aiming so good. Hosing down with a machine gun's not going to increase the chance of you hitting your target. In fact, it will rapidly increase the damage to bystanders.
And the chance of you not getting a good result, right?
Right.
And if you don't have experience with a machine gun, like you won't understand the way you lose the iron sights, right, under automatic fire in some weapons. Like you were saying, there are some weapons that really do kind of function like a paintbrush, right? Open bolt submachine guns in smaller calibers, for example, once you get past the third round, you really have acquisition of the sights, and they really can be used that way, but they do take a certain degree of
training and familiarity, and somebody who picks one up for the first time not liable to do that, right?
No. In fact, and we have seen what 9mm open bolt guns can do in extremely untrained hands, which resulted in the death of a shooting range vendor at one point. But anyway, that aside, that was kind of struggled through, right? Yeah,
it was. It wasn't articulated in a very like a very convincing manner. And of course, from the moment that we had Easterbrook and Wood, right, they're looking for any opportunity they can to be aggressive, because they're litigating for the state is what they're doing. It's very obvious that that's what they were doing by their line of questioning. Like, very, very few of their questions were asked in good faith.
Well, but they did jab the state a bit,
a little bit, not nearly as much as they were jabbing the plaintiffs, but it was pretty evident what they were doing. So I'll admit, even if you did like correct Easterbrook, like, hey, that's not how machine guns work. Hey, we're not talking about grenades. Hey, dude,
he would just move on to his next thing as the thing.
Right. This case isn't about Stinger missiles. He wouldn't care.
No, and like, he would have thought of another horrible two parade.
Right.
And so that's why, this issue wasn't material, but it did lose. It ate up a lot of valuable argument time that could have been, used on the core matter here, which is that these are protected implements that are all over the freaking country.
Right. And Thomas Magg was another lawyer for the plaintiffs, and he started right off with the NFA doesn't ban anything; it just taxes things, subjects things to higher regulations. You can own machine guns; they're not banned; they're taxed. You can own Stinger missiles; they're not banned; they're taxed. You can own hand grenades; they're not banned; they're taxed. And then Easterbrook's like, "Oh no,
I don't think that's right.
I don't think that's right. Hand grenades, Stinger missiles, they're banned. They're banned by the same federal statute that bans body armor."
You did say that.
Which one is that, buddy? Which one? Can I get a cite for that?
Yeah, it's God. But that was actually one argument that was brought up in one of the amicus briefs in these cases, that they're doing all this machine gun talk. Well, the simple fact is, the NFA didn't ban them, right? We've covered that to death. This statute in Illinois that Illinois is trying to push forward would treat them more harshly than machine guns are presently treated. Yes. Although Illinois can get around that by saying, well, it bans the private ownership of these things. However, with and this was a direct point that was brought up in one of these amicus briefs, destructive devices are not prohibited.
Yes, they're not prohibited in Illinois. So
at all.
I know a guy who's got a 40 mil underbarrel.
Yeah.
Like you can own grenades and grenade launchers here.
Yes. And so that would have been a great counter argument to that, which is not only is it not federally prohibited, of course, Easterbrook wouldn't have listed, but Illinois does not prohibit it.
Well, Easterbrook would have listened and he would have gone,
yeah. Well, but anyway, so, like we're saying, I'm not saying that I could have done any better. I would have probably made very different mistakes.
Right. But you're in such a hostile environment with Easterbrook being in the room that you could argue perfectly and you could correct him every time he says something wrong. He's still going to get away with saying wrong things, and he's just going to use whatever you say to try and like him getting you off topic is kind of his goal here.
Yeah, he wants to ring fence you into saying that you're arguing for the constitutionality of machine guns, which, frankly, is a position I would like to be in, but.
Right. He's looking for he's basically already got his brief written, right? And he's just looking for more things that he can use to say
what a bad and weird,
Right.
And again, we shouldn't be focusing too much on the particular judges. Of course, that's a concern I have to have as a print practitioner. You can complain about whatever you want. But because, there were other judges on the Seventh Circuit that could have, if the dices roll and they were on it, would have resulted, in the same outcome. But I think that are there any more points you want to hit on? So there was
arguments? The whole time through the state's opening, right? They didn't really get pushed back on. They sort of just said their nonsense and made their peace. It wasn't until the very end, that the state got back up and was doing is there any more questions? And Easterbrook asks them, do you think that the Winchester repeating rifle is protected by the Second Amendment? And the state answers, we're not sure. And then Easterbrook asks them, is that your final answer? And the state of Illinois, I believe their lawyer laughed nervously and said yes. Like spaghetti was spilling out of his pockets quickly because I think he realized what he said.
Yeah.
Will that change the outcome? No. But perhaps at least for Easterbrook, right? That
it would have been nice. I guess what he was thinking, he would have liked to say that the government,
right? Look how reasonable the government is. Oh, they're saying that the old, because Easterbrook's trying to shop through analogs, and there was, I guess, earlier during the state's opening, one of the questions that Brennan asked is, what do you think your best analog is here?
Right.
For banning these guns, what's your best historical analog? And the state says the fire codes, you have to store gunpowder on the top story of your shelf, or just top story of your house in containers no bigger than 10 pounds, and it has to be in a tin can. And is a fire ordinance thing.
Right.
And the state's answer was it's the gunpowder storage law, which is one
of the reasons modern gunpowder is sold in those odd numbers.
Right. And so Easterbrook did at least interject on that, and he was like, that's a fire code. It had nothing to do with guns, right? It wasn't a gun regulation, it was a fire code thing, because you could still own as much gunpowder as you wanted. It just had to be stored appropriately. And then the state came back, but it's but it was designed to keep first responders and police safe. Like, oh, come on, dude. There's no way you believe that. Come on. You expect anybody to believe that's crazy?
Yeah. So I guess wrap up on the Illinois assault weapon case is then it doesn't look like we won.
so there's not going to, the injunction's not going to come about at this stage. The theory crafting that I've seen so far is it'll be a question of how long this panel sits on making their decision, because on their one hand, they want this ban to stay in place, and the longer they sit on it, the longer before it can be appealed. On the other hand, these people are, to some extent, they believe they're very smart, and admittedly, they did a good job of the thing that they did, as much as we don't like it. And so they may not want to sit on their opinion for too long. So either they do it pretty quick or not. Who knows, right? The schedule on these things is always a mystery.
Right. But remember, that doesn't mean this case is over or that it's lost.
Certainly. So the question is,
just for the audience. Yeah.
So the question is, where do the plaintiffs go from here? So once the opinion drops, I imagine it'll be up to the actual contents of the opinion what route they want to go on.
Yep.
If the route that Wood and Easterbrook take is one that just craps all over the test in Bruin, probably the best course of action is to try and appeal it to the Supreme, because the Supreme Court's already showed interest, right? The Supreme Court already showed this case to the full court, and they said they wouldn't take it because the Seventh Circuit said that they were going to expedite the whole thing and hear it as quick as they could. So the Supreme Court is at least aware of this case, and they've at least done a little bit of research on it already. So if Easterbrook and Wood come up with some opinion that just craps all over the test in Bruin, appealing to the Supreme
that's the
Court.
question. So here's the thing, that the question here is, are they going to try to recreate a two-step question?
Right. Are they going to come up with a whole new test, or they,
which just doesn't get you into historical analogous regulations?
Right.
Because there just aren't any.
Right. Or just frankly disregard what Bruin says and be like, oh, yes, the fire codes are completely analogous to banning 90% of the guns that are sold today.
Right.
Like I think if that's the way they go, Supreme Court's the way to.
But they don't even have to do that. I mean, they can do this pretty clean and get very deferential.
Oh, I think if they do that, if they do that, maybe the smarter move for the plaintiffs is try and get it heard en banc. So you have the whole seven. If they manage to wiggle their way into making it look like they obeyed Bruin, right? Because for the Supreme Court likes to, what's the big three things they look for? They like cases where there's a circuit split. They like cases where the government's losing. They like cases where it's fully briefed. And in this case, it's not going to be any of those.
Right.
So the Supreme Court would really only take it if it's very obvious that they're being disobeyed.
Right.
So if it's not obvious they're being disobeyed, like it at least looks like they tried to do a Heller and Bruin application, then having the Seventh Circuit hear it en banc would be a lot better, because the judicial makeup of the Seventh Circuit is better than what we had on this panel.
It's better than it's better than it was before. It just, it also depends on who you ask, and also in terms of what cases you're hearing, right? So I don't want us to seem too partisan, although we are pretty aggressively single issue advocates. But yeah, so that's the shape of the assault weapon case. It is it's going to be a long haul, I think, is the only takeaway we can really have.
So it'll be cross fingers and knock on wood that things go well before people have to start signing over affidavits and detailing to the state all of the guns they own.
Right.
And of course, if we get close to that point, I've heard some lawyers in some of these cases talking. They have the option of doing a whole new lawsuit specifically aimed at because all of these lawsuits so far aren't dealing with the affidavit really. They're dealing with the assault weapons ban and the mag ban, because you can only fit so much into one lawsuit. Right. And they decided it's a tactical decision. They would leave the door open to, if we get close to that cutoff date where the guns need to be, you need to sign a bunch of paperwork and pay some money and then tell the state all the serial numbers and guns you own and send them a picture of all of the guns you own in that configuration, such that you can't change the configuration and make things more salty weapon later. So they have the option of filing a whole new lawsuit that says, hey, this particular provision of this ban is unconstitutional on its own. regardless of what, because currently they're talking about the sale ban. So the registration, essentially what it is a registration requirement. They could do a separate lawsuit over still. So don't, people out there who are doomer posting, I know I've seen some of them. You might be right to doomer post, but maybe there is still some hope.
Yep. All right. So last up is a case that I think is very interesting. This is the Junior Sports Magazine's case, and this is targeting California's bill, which concerns firearm advertising that might reasonably be construed to be attractive to minors. And if you guys were wondering why every weapon site that you go to that sells guns and gun parts and stuff all of a sudden started, had that awful pop-up asking if you are 18, this is why. Companies do not want to be caught up in this mess. And so this was a magazine, Junior Sports Magazines. A lot of what they did depended on advertisements from, like companies like Cricket and Winchester's, right? They have youth models.
Marlin does, recoil. Savage does.
Yeah. Low recoil ammunition, stuff like that. That frankly, what the target is parents of juniors that they want to get them into the shooting sports.
Yep. So
the question here, it's really fascinating because the legislative record is replete with evidence, and even the court recognized that the legislative record shows that the actual intent of the law was to target pro-gun speech.
Yes.
Like straight up. The animus was not to there's no proof, and because it's ridiculous, right, to suggest that anyone was advertising directly to the minors to hey, use these guns in crime.
Right. And then there's two steps there though, right? Because like you'd sort of led to there. The first step is anybody actually advertising guns to children who can't buy them in the first place, which would be a really stupid way to advertise things, right? It would be like me running a bunch of ads for machine guns even or something.
You can advertise guns to children. You certainly can, because it is lawful for children to use guns. And so, the target there would be just like, advertisements on Nickelodeon and what have you. The advertisements are not to the children. The advertisements are to convince the parents. To purchase things,
to buy the guns for the kids. But the second step there is, so who cares, right? Because it's legal for kids to shoot guns and it's legal to buy guns for your kids. So the only public safety interest this would serve is if kids are having guns advertised to them, and then that makes them want to shoot people.
Well, and that's what the government cited. So what the government put, and this is interesting, what the government wrote in the bill was okay, so let's take a step back here. First off, there's First Amendment concerns. The problem is the Supreme Court fudged us very bad. The problem is that the Supreme Court long ago fudged us pretty bad in terms of commercial speech. So there's two categories, right? There's pure speech, which is like what we're doing right now. This is pure First Amendment protected activity. And then there's commercial speech, which is speech that has been defined as that which its intention, its primary intention is for profit, right?
Right.
Its primary intention is to move a product, and so that is given a lesser protection. It is not like, whereas pure speech bans are strict scrutiny, which basically means the government can't do it. Whereas commercial speech, the government it can get away with it. And that's what comes under the Central Hudson test. So the touchstones there are whether the speech is lawful and truthful. Those are the first one there.
Yep.
The first questions under Central Hudson is the commercial speech lawful and truthful? Because if it's unlawful and misleading, it's regulable in a whole different way. I think this is clearly yes. Minors are allowed to use firearms in California in less ways than in the United States, but certainly there exists lawful activity that could be the target of this bill. And does there exist truthful advertisements? So it does exist, right? So then we proceed next, which is whether the government has a compelling interest, right, to protect, and then whether the targeted speech is not overly broad so as to target the government's focus,
right?
Which is the government interest, the harm that the government is seeking to protect against. And so I'm going to pull up the claw here. I got the claw pulled up, the bill text. So here we get. In this enactment right here, this state has a compelling interest in ensuring that minors do not possess these dangerous weapons and in protecting its citizens, especially minors, from gun violence and from intimidations by persons brandishing these weapons. So some of you might at first be thinking, oh, well, they've kind of got the interest, but do they?
Right. That's a good question.
That minors do not possess these dangerous weapons.
Like
that
can they just ban that? So
yeah, no, they can't. So no, they do not have an interest in preventing minors from possessing weapons because it's lawful, right? The gun violence talisman invocation here, right, is the ordinary, right? And it's, yes, the government has an interest in protecting its citizens from gun violence. It does. The government does have an interest, right? But then there's a question of means and fit. Does this law prohibit more than is reasonably necessary, right, to achieve that result? And the answer, I think, is obviously yes. But that's a lot of what was being embattled here in the junior sports magazines case. So what one of the judges was getting at is, was asking the plaintiffs, well, the question of government interest, is that a factual or a legal determination, right?
Mm-hmm.
Now, do you know the answer to that?
I don't know.
It's a good question.
Right.
And, the plaintiffs were saying, the plaintiffs were saying, I think it's legal. And the reason they were right. The reason they were getting at that is because on appeal, if it's a question of fact, the court can only step in and substitute its judgment when there is it's an abuse of discretion standard, which means the judge below was just so clown shoes, knuckle dragging, window licking in its analysis that there's just no way that it was right. And the plaintiffs were kind of saying, well, I think we win either way. And they're like, come on. But no, if it's a legal question, no, it's de novo review here, right? The court gets to look at it. The appellate court gets to look at it with a clean slate. So it was kind of poking the government. It was poking the plaintiff, saying like, oh, come on, is this factual or is it legal? And later on, they were saying, and they were asking, what's the case law? Later on, the same judge when it was grilling the government attorney, there is case law. It is a question of law as to whether the government has an interest, and Safari Club is the case there. And the government just kind of went, this week wiggled around that. And so yeah, when they were talking about the plaintiffs, it was this case was so interesting, but because it's so unsexy compared to the other ones, it's not getting the coverage that it really should. But this case is important because the question here is, can California, because the California law, what it gets at, like here, let me pull up the claw. Here's the claw again. A firearm industry member shall not advertise, market, or arrange for placement of an advertising or marketing communication concerning any firearm-related product in a manner that is designed, intended, or reasonably appears to be attractive to minors, right? And so the way it gets at these firearm industry members is basically anyone
Yep.
who sells anything related to firearms.
Yeah.
And these products are anything made or distributed in California. And it's not just saying that you're acting in California, but it's marketing for an item that is reasonably foreseeable might be possessed in the state of California.
The interesting thing, and I know they touched on this, in the actual, part of the oral arguments, is it's really, really unclear when this begins to, like, when you can point your fingers at Hollywood squarely, right? Because there's a very obvious example of a movie which has guns in it, which is like a barely disguised gun advertisement. And of course, everybody who's seen movies recently, right, knows I'm talking about John Wick, especially the most recent one, where like Terran Tactical logos are proudly on display on half the guns in the movie that Keanu Reeves touches has Terran Tactical logos on it. Like the guy was practically in fact, he probably was actually the movie armorer. But wouldn't surprise me, actually, now that I think about it. But like, that movie was one great big gun ad for Terran Tactical. Is that movie itself something you can ban in California? Because Terran Tactical is based in California.
Well, that was the question his gun the judges asked straight up.
Possessed there.
Yeah, he straight up said, he's like, "Why are you going after this?" He asked the government. Well, and he asked, I got this in my notes here. How does this law directly advance the state's goal? Is there any evidence that a minor has unlawfully purchased a gun in California? And the government starts squirming, right? And finally, and then when press says, well, no, there's not evidence in the record of that specific incident. However, the case law says that there doesn't have to be specific incidents. And he just straight up says, is like, so then the government asks, well, could California pass a law that banned advertising vehicles aimed at minors under the theory that a minor might sometimes misuse a vehicle?
Can you ban Hot Wheels? It's encouraging kids to drive fast.
Yeah, it's a fascinating question, and then one of the judges straight up said is like, isn't the real thing here Call of Duty? Like, if there's something that's driving children to want to play with guns, is it? And then it was funny because the judge was kind of savage. He was like, I've never heard of Junior Sports Magazine. Then I have children. I don't think this is what's doing. Isn't it Hollywood and Call of Duty? Which, of course, we've hated hearing about that since the Jack Thompson era, right? But
it's true.
It's true. It's completely true. So, and the government's like, well, we don't have to only target the most prevalent thing, which, yes, they can go piecemeal. But the thing they target definitely still has to have a connection to a legitimate government interest. And I don't.
They're pretty far from that at this point.
And then the big result here, guys, the way that California rates these things, this is what is driving all of those websites to have those little clickerators.
Right. Are you? And if California gets away with this, this isn't their last stop. This isn't the last choo-choo train station. It won't be much longer before California does some version of this where it's like, oh, well, anything that's a gun-related item has to go through an FFL, and this applies if it could reasonably be possessed in California. Mm-hmm. So California will force gun companies in other states to only ship things to FFLs, or they can't do business in California.
Yeah.
And then that would probably be the bridge too far, where distributors and places or distributors and gun companies are just like, yeah, we're cutting California off. But until then, California has a lot of people living in it. And even if you look at political makeup maps, right? 40% of California votes red pretty consistently. And because California is such a populous state, that 40% of people is actually a lot. It's a very big market. And of course, I realize the red-blue makeup doesn't always tell you who's going to buy a gun or who's not, but it's probably the best, the easiest metric, easiest way to demonstrate that. There's a lot of people in California who do want to buy guns, which is why these manufacturers don't just like cut California out completely and leave them alone.
Right. it's wildly problematic. I'm hugely concerned about this case, and you know what? It's not clear from looking at it how the preliminary injunction is going to go, because that is also what this case is about. These cases are all about prelims, but I mean, the judges were very, very firm with the state.
Yeah, they're straight up skeptical at times, even like, are you guys
how can you say this is not more extensive than necessary? That's what was asked at one point.
Right.
And the government kept saying, oh, well, but we can do this because look at all these cases. And what they were leaving out, that all the cases that we're citing were about advertising of alcohol and tobacco to minors, which could not lawfully have those items.
Right.
So this is... the judge also said this is not like trying to ban cigarette ads across from school yards, right, which they had gotten away with before. This law seems to really be missing a direct relationship to any legitimate government interest. And this is what the plaintiff pointed out, is that we are talking about the government's asserted interest in preventing speech to address a harm it hasn't shown a single connection to that speech. And the fact that it's, to me, so now this is me speaking as an advocate, I don't think it ought to matter whether that speech is for commercial gain or not. Because, mind you, commercial speech enables pure speech. And this is what the magazine's argument was, is that without commercial speech, how are they going to afford to print their articles? Right. And so there are going to be pure speech articles in that magazine about teaching youth to safely use firearms. And how are they going to print that unless you can advertise the new Cricket or or any of the other companies that? And so I think it's clear that what the state is attacking here is they're trying to accomplish the same objective that they have accomplished in many states, including my own, which is throttling entry into firearm culture.
Making it more difficult, making it more expensive, making it less, for lack of a better word, sexy, less appealing, less something.
Well, because think about what the 18 to 21 case has accomplished, right? Is now saying, like basically that you cannot purchase a firearm until you're 21. That would have completely changed my life if I did not, on my 18th birthday, decide that I was going to walk up to. I walked from Palm Beach Community College to the Delray Shooting Center, which. Do not ever go there. This is so far from an advertisement. It's unreal. Never go there. Bad place. But I bought an M1 carbine on my 18th birthday. I bought an M1 carbine, and on the way back, I bought a pack of Pall Malls because I wanted to exercise. I didn't even smoke the cigarettes. I gave them to a homeless guy, but I wanted to exercise what I could do then. My life would have been so completely different. If I could not have purchased a firearm until I had already stewed for 3 years in a hyper-progressive learning institution, I don't know if I ever would have. I really don't. And so when you limit that access to later on, and then limit any appeal or interest, and let's be real here, no one is advertising for children to criminally use firearms.
Nobody's advertising for criminal use in the first place, because that in and of itself is legally objectionable. Well,
it would be regulable on itself. You can do it, but then the state can prevent you from doing it. So it's a whole different thing here. What they're doing is just making it difficult to talk about firearms at all. Them couching it in terms of possible minor attractiveness, it's not the real motive. Right. That's them playing I'm not touching you games with constitutionality.
And they'll use kids as the scapegoat for it, because it's something where there's because they're trying to follow the playbook of the cigarette and alcohol things, and I'm sure that's why they think that it's analogous.
Right.
Like, because
But it's
prior to their bans on advertising cigarettes and alcohol in children's book or whatever,
right.
It's not legal for mommy to hand the toddler a bottle of booze and having toddlers get crunk. It's not you can't do that.
No matter how legal it should be, mind you. That's the legal distinction.
But mommy can take toddler to the range and show them how to safely unload a gun. That's
which was a massive point of national pride, by the way, in the founding era, where it was written in quarterlies that children in the United States were in the colonies, as it were shouldering the likeness of a rifle before they could leave the crib. This was something that we were massively proud of.
We used to be a real country.
We did. But so that's why, guys, I just really want to drive home how important this one really is. This is going to be, this could have serious implications on how we are able to talk about this stuff.
Right? Because okay, so again, speaking theory crafting, doom crafting, the
doom crafting, yeah. Look, so Brandon Herrera,
right?
Could that be
his YouTube channel? His audience is all 14 and they don't own guns,
unquestionably,
which isn't
attractive
bad, right?
to minors. It's not bad on its own.
He pipelines kids to being interested in guns,
but yeah. So, ought Brandon Herrera's content be regulable in California, because it is most certainly commercial, right? And sponsored and some other things, right? Is that attractive to minors? This is very. I always say
is. It certainly is.
The slippery slope is not a good thing to engage in, but I don't think this is like it's one slip. It's not the full slip, right? What I'm talking about here. It's wildly problematic. And so keep an eye on this one. I hope they secure a good result here. I am not 100% sure that they would, because the court was definitely grappling, although they certainly seemed to be hostile to this idea. The court did recognize that we are talking about eminently constitutionally protected conduct, which, although alcohol should be constitutionally protected, it in fact is not. There are still remnants. And in fact, there is a constitutional scheme of alcohol regulation enshrined in our now flawed document. But the two could not be further from a legal perspective. But anyway, yeah, so that's our, we originally said this was going to be a 15-minute video.
For a real quick 15-minute breakdown.
Yeah, we lied. But anyway, guys, this was our pontification of these three major developments. So it may not have been a quick breakdown, but in the amount of time it would have taken you to listen to just one of them, you got our full analysis on three. So I think that's a pretty good deal. 3 for the price of 1.
That's
true.
What
do you think?
It's pretty good. I hope everybody enjoys it. It was
No, do let us know if you guys like this type of stuff. This is much easier for me to do than the normal content, which I will be producing, I promise.
We're doing an outline. There is an outline for the courts video. It will happen. Oh,
yes, that is. And Sam has been helping me with some of the state-by-state videos. Haven't you, Sam? It's an enthusiastic yup. But all right, guys. Anyway, yeah, let us know if you liked it. Let us know what your favorite color is. Be sure to write down the favorite thing that you saw the rat do.
Yeah, you have to do the rat do things. Those were funny.
Yeah, those were.
And then everybody will have to watch the whole video. We're gonna trick them. We're gonna trick them real good. Watch the whole. Favorite part was whenever the rat took his wig off and he beat Gavin Newsom into a coma with it. It happened.
So also last time I experimented with. I was quietly protesting clickbait by putting an AI generated anime girl on the cover, and the video performed oddly well.
Put a big titty anime judge GF.
Should I actually do that?
That'd be funny.
I think I can make the AI do that.
That'd be good.
All right, I'm gonna just do that. But I don't know. I think should we experiment with giveaways? Because I want to give away something to the what we arbitrarily deem to be the funniest.
That'd be good.
The funniest comment of what the rat did.
That would be good.
Yeah. So you got to comment I liked when the rat did X thing that the rat didn't actually do. And I'm not promising you shit, but I am telling you.
There might be a giveaway.
I'm telling you, we may, just, to avoid SEC things. There is no consideration. I am not promising I'll give you a damn thing, but I might give you a cool thing I find on my desk. If I both think that your comment was funny, and I find a way to contact you. But you should also please subscribe to the channel and also be nice to us and join the Patreon, get access to the PvP Discord server and all of that nice stuff. But anyway, guys, that's it for the moment. As always, we will see you next time.
Bye-bye.